Court does call the case of the people versus Charles Williams.
We are jumping straight into a courtroom morning that wastes absolutely no time. Case after case, defendant after defendant, and right out of the gate we hear something critical: the waiver of a preliminary examination. That is not just paperwork, that's a strategic move. A preliminary exam is where the prosecution has to prove probable cause. It's their first real test. When a defendant waives that, they're essentially saying, let's skip this step and move to circuit court. That can mean negotiations are already happening behind the scenes. It can mean a defense strategy is already in motion. Notice how Judge Simpson, calm and methodical, ensures the defendant understands exactly what rights he's giving up. This isn't optional. Courts must confirm that waivers are knowing and voluntary. That's procedural justice in action. And here's the bigger question for you. If you were facing a charge and had the chance to force the prosecution to show their evidence early, would you waive it? Or would you make them prove every inch of their case? We're about to see multiple defendants making critical decisions that could shape their entire future. Stay locked in, because some of these rulings will flip expectations fast.
Your name, sir? You're a prosecutor. What? No. Take your time.
I'm so sorry. If you're two different people.
All right. He's waiving.
Yes, Your Honor. You have to sign.
I do. Mr. Williams, you're waiving the right to a preliminary examination?
Yes.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Brown.
I'm going to on behalf of Charles waive and request retrial.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for April 9th, 2025, 1:30, Judge Conlon.
Yes,
Brown, continue.
Thank you.
Court does call the case people versus Mike Jones.
Hey, we're two different people.
Go ahead.
Good morning, Your Honor. Assistant Public Defender Ben Dunham. On behalf of Micah Jones, who stands to my right. Mr. Jones, would you state your name for the record?
Thank you. He's waiving.
He is waiving, Your Honor. He is signing the form right now.
Sir, you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count. Counsel, your turn.
What date, Your Honor?
You waive reading of the information?
Yes, sorry, stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
April 7th.
April 7th, 2025, 1:30, Judge Hammoud.
Thank you, Your Honor.
Thank you. Bond continue. Court does call the case of the people versus Calvin Fuqua.
Insurance grant on behalf of people, Your Honor. Brown Brown Street on behalf of.
Your name, sir? Thank you. Is he waiving? Okay.
This is the date and time set for examination. The officer involved is informed by the officer. Start off with the consent notice there, or today's date, he is failed to appear to be part.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's on defendant's motion without prejudice.
And just like that, dismissed. But pay attention to those two words, without prejudice. That's everything. That means the prosecution can bring this case back. It's not a permanent victory. It's more like a reset button. When the prosecution says they're unable to proceed, it usually means a witness problem, missing evidence, scheduling issues, or procedural complications. Something wasn't ready, and in criminal court, timing is critical. This is a reminder that cases don't just collapse because someone is innocent or guilty. Sometimes they collapse because the system itself isn't ready. Now ask yourself this: if you were the defendant, would you feel relieved or anxious knowing the case could come back at any time? That uncertainty can be almost as stressful as a conviction.
Thank you. Court calls case People versus Zeni U.
Ready.
You have to
The job's done on behalf of the defendant. Let's get you. Roll up.
Thank you.
Today's date talks about preliminary examination. At this time, if you are unable to proceed as count one, and ask the court to remand on counts 2 and 3.
No objection to this dismissal.
Count one is dismissed. The case is remanded to the 15th District Court on counts 2 and 3. I'll set a pretrial date,
April 16th at 9 a.m.
April 16, 2025, at 9 a.m. 9 a.m. before Judge Perry.
You've already given my client permission to go to California.
I did?
She returned for today's date. She wants to return to California. She'll make her court case. Judge Perry usually allows that. So we're asking permission.
No objection from people who have.
All right. So she normally resides in California, is that?
After this today, Your Honor, she re-engaged with her mental health treatment, which is based in California.
Okay.
And that is her permanent.
So what I will do is her bond will continue. Defendant may travel. And she resides in California, correct? Right.
Yes.
Okay. So I'm going to word it this way, that she may travel and reside in California.
This is a subtle but significant ruling. Bond continues, and she's allowed to travel and reside in California. That tells us something about risk assessment. Judges evaluate flight risk and danger to the community. If Judge Simpson is allowing out-of-state travel, that signals he believes she will return. Bond isn't a reward, it's a balancing act. The court must ensure appearance at future dates while respecting the presumption of innocence. Notice the condition: she must return for court dates. That is non-negotiable. Violate that, and bond can be revoked instantly. Here's the engagement question. Do you think courts should allow defendants to live out of state while awaiting proceedings? Or should geographic restrictions be tighter until the case is resolved?
Must return for court dates or court proceedings. Of course, if Judge Perry allows something.
Thank you.
Right, thank you. Court calls the case People versus Tama Harris.
Hey, everyone, this is people.
Where is he? Was lurking around all morning. Next to him, Bernstein. You know where he is? Okay, gotcha. Appreciate it.
Bernstein on behalf of Ms. Harris.
Your name? All right. I have before me a plea form, and I'm assuming this is supposed to be an attempted. And it's okay. Huh? You mess this all up. Hold on. I don't know if my pack codes are. They're not. They're not. You did. Jeez, oh Pete. No, don't worry about it. I'll fix it. So I think how this is supposed to read, and now kind of does, that she's going to be pleading guilty to the charge of attempted resisting and obstructing a police officer, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Yes, sir.
Now this is a pivotal moment. A guilty plea to attempted resisting and obstructing, a misdemeanor punishable by up to 1 year. But look at how carefully Judge Simpson walks through the rights being surrendered. No trial, no appeal, no presumption argument. Once that plea is entered, it's done. And here's the legal nuance. Attempted reduces exposure. That suggests negotiation. The original charge likely carried more weight. In exchange for the plea, count 1 gets dismissed. That's leverage at work. When she admits to interfering with an arrest, the judge establishes a factual basis. That step is critical. Courts cannot accept guilty pleas without confirming that the facts support the charge. Let me ask you, was pleading guilty the smart move here to limit consequences, or should she have pushed for trial?
Man, what is one?
Where the whole.
You have gum. Check that. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. Is that correct? That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? All right. You understand also that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights from today, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on there for.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. And because you believe that you're guilty of this offense? February 8, 2025, at the location of 1490 DeSoto in Ypsilanti Township, Washtenaw County, State of Michigan, did you come into contact with police officers?
Yes.
What happened that makes you think that you're guilty of this offense?
I was interfering, obviously, with
So somebody was being arrested.
Yes.
You knew they were being arrested, and you interfered with that arrest. How did you do that? Okay. And you knew it was a police officer doing that,
Yes.
correct? All right, counsel, have I complied with the court rules?
Yes, sir.
Court will accept the defendant's plea to count 2. Plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
At 10 a.m. before Judge Washington.
May 15, 2025, 10 a.m. before Judge Washington. So when you grab the arm, how'd that work?
That brief exchange right there, that's human courtroom energy. How did that work? And the answer, not well. It's almost dry humor, but it underscores reality. Interfering with police arrests rarely ends favorably. Judges sometimes use light commentary like this to cut tension, but the legal gravity remains. A conviction still carries probation, fines, and a permanent record. This is a reminder that split-second emotional reactions can turn into long-term legal consequences. One grab, one moment, months of proceedings. Think about that. Would you react emotionally in a heated situation, or would you step back knowing the legal system can be relentless once you cross that line?
Not well. Yeah, okay. Just check it. Bond will continue. All right, thank you. Yeah, it didn't work out well because you're here, didn't it? Figured that out on my own. Court calls the case. People versus Anita Payne.
Amber choice, we're gonna be met people. We're ready.
Hello, my name is Anita Payne.
All right. I have before me a plea form that indicates defendant will be pleading guilty to attempted custodial interference or kidnapping custodial interference, the 6-month offense. Upon her successful plea to that charge, the kidnapping charge, custodial interference, would be dismissed. There's further the agreement, although, well, I guess it's me. It's okay to seek a deferral pursuant to statute.
That's all.
That's the court's full understanding of the agreement. Is that correct, Mr. Brown?
That is correct, John. Thank you.
Ever sworn.
So I swear, so keep the whole thing, but oh, yeah.
Mr. Leader Payne.
Sure. Go ahead. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted kidnapping custodial interference. Is that correct? That is a misdemeanor punishable by up to 6 months incarceration and a $2,000 fine plus court costs.
Attempted custodial interference. This one hits differently because it involves a child. The judge carefully confirms timing. 24 hours passed. The child was supposed to be returned. That detail matters. Criminal custodial interference hinges on violation of custody orders. 6 months maximum exposure. And again, a plea deal reduces the original charge. Count 1 dismissed. That's negotiation in action. Family-related offenses are emotionally charged. Sometimes they stem from conflict, not malicious intent. But courts enforce custody orders strictly. Here's the question. Should custody violations automatically be criminal matters? Or should they remain primarily civil family court disputes?
All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights. You understand you're giving up your right to appeal of rights. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes, sir. Oh, no.
All right, let's try that again. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge? Has anybody threatened you or coerced you? You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes.
December 2nd, 2024, at the location of 4511 Packard Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custodial possession of a child at that time? Physical possession?
Yes.
All right. And at the time that you had that physical possession of the child, was that child supposed to be returned to the other parent?
Yes.
At that time? And had a 24-hour period passed?
Yes.
Since, I guess I should clarify that. The child was supposed to be returned at least 24 hours prior to the time that you did.
Yes.
All right. And you just failed to do so.
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor, the people are set. It's set.
The court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
It's got a TV docket.
Sure, it could. I can put it wherever I want. No, what? You're saying that's where you believe it belongs.
April 1st. At 1 p.m.
Sentencing will be April 21st, 2025, 1 p.m. And that's before me. Yes. I saw you sign the sentencing judge waiver and I didn't know why. Was he trying to not have me? What was he trying to do? He was up to something. What? Oh, okay. Yeah. All right. It'll be before me on that date. On your way out, you may want to stop by my probation department to get that started, that process. All right. What?
Or
April 21st.
Well, I was going to set another date, but then Childers jumped in. So I set another date and you weren't listening. The only person that was listening was your client. Are you good now, Lou? Are you good? I know you're good. Are you good? Okay, bond continued. What? No, it's at 1. I don't know why I bother talking. Just like go.
I got it.
You got it? Finally? Ma'am, what date did he write down?
The 21st at 1 p.m.
Okay, good enough. All right. Thank you. Just double checking. Court calls the case of the people versus Robert Jones.
As then we have.
Assistant Public Defender, you have Mr. Jones. With motion now, Mr. Jones, statement for the record.
All right.
It is going to be no.
We have a form that indicates that the defendant will be pleading no contest to the charge of aggravated domestic violence, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There is the agreement between counsel of no upfront jail. We don't do that, but you see that that's the agreement, understanding of counsel.
That's right.
All right. Is that a correct statement? All right, let's have him sworn.
Raise your right hand. You solemnly swear or affirm to tell the truth and whole truth, nothing but the truth, yes.
So it is his court's understanding that you are going to be pleading no contest to the charge of aggravated domestic violence. Is that correct? That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand it? Do you understand what a no contest plea is? Let me explain 2 things about it just to make sure. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Now, understanding and the basis for the no contest plea is potential civil liability counsel.
Well, I can remember this is about 5 years old.
Sir, to the charge of aggravated domestic violence, how do you plead?
No.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal over it. Are you on probation or parole? You are? Were you on probation or parole at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2416061. Any objection to the court having reviewed that report?
None from defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Now we shift to aggravated domestic violence, and this time it's a no contest plea. That's strategic. A no contest plea means the defendant does not admit guilt but accepts conviction. Why would someone do that? Civil liability. The judge even references it. If there's potential for a civil lawsuit, admitting guilt could be used against you later. A no contest plea avoids that admission while still resolving the criminal case. Notice also, counts 1 and 2 dismissed. Again, negotiation shaping outcome. This is a layered legal maneuver. It's not just about criminal exposure, it's about future financial risk. Would you choose no contest to protect yourself from civil fallout? Or fight to clear your name completely?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be, it's a DB.
April 21st at 1 p.m.
April 21st, 2025, 1 p.m. That is before me. Bond will continue.
Thank you.
Thank you. Sir, you may want to stop down at the probation department down the hallway and just check in and get it started. Okay, thank you. Court does call the case of People versus Cody Tor.
Yes, and on behalf of people. Charlotte, on behalf of Mr. Tournier.
All right. And what are we doing?
Your Honor, today's date comes up with preliminary examination. At this time, the people are unable to proceed as to count one and would move the court to add count three of telecommunications, now use domestic relationship, and remand on count two and the added count three.
Do you want me to add a count?
Yes.
Okay. Count three is what?
It's the telecommunications now use domestic relationship, and then I have the pack of court.
Oh, yes. Yes, PAC code.
750.540E1H. And it's a 6 month, $1,000.
E1H.
Yes.
Okay. That is actually count three. And counsel, you waive presentation of the complaint on that charge.
Yes, we do. We have no objection to the dismissal.
All right. And your client enters a not guilty plea to count three.
Yes, Your Honor.
All right, very good. I'll enter that not guilty plea to that charge. There being no further further reading of that. Count one is dismissed. Set this for pretrial.
Here we see procedural reshuffling. Charges amended. Count 1 dismissed. New count added. Not guilty entered. This is prosecution recalibrating. When they can't proceed on one charge, they pivot. Adding a telecommunications domestic relationship count suggests alleged threatening or harassing communication. These cases often hinge on text messages, call logs, digital evidence. Pretrial dates matter. That's where plea negotiations intensify. Evidence gets reviewed, motions filed. Let me ask you, when charges shift mid-process, does that feel like fairness or tactical pressure?
April 10th at 2 p.m. before Judge Fresh Hour.
April 10th, 2025. What time?
2 p.m.
April 10th, 2 p.m. And that's before Judge Fresh Hour.
Your Honor, I'm not available at the time. I have a preliminary examination in Oakland County at 2 o'clock. Is there another day?
Let me see if we have one. You may have to deal with Judge Fresh Hour staff. We don't have another pretrial.
I'm just checking it.
I'm thinking it's going to be a DV. That's a DV day.
Correct.
Okay. Good. Yeah, one.
The next one would be the 24th at 10 a.m.
Work for you?
It does not.
Okay. Why don't I do this? But why don't I give you, so there's at least some additional time, the 24th at what time? 10? At 10 a.m. before Judge Fresh Hour. I'll let you then, that'll give you time to contact them.
I appreciate that. Thank you.
All right. Bond will continue. Thank you. Court has called the cases of the People versus Elroy Love. All three cases.
Santino, hearing on behalf of Mr. Love. Mr. Love, can you please state your name for the record?
What are we doing?
In order to end the date time set for preliminary examination, at this time, numbers, internet statute, can't pull up the file numbers. Do you need assistance? Yes.
Your internet now?
You're sending somebody over.
So hold it. Why is his working?
Find out how this works. That's what
Why'd they give her the cheap stuff? Okay, it's just a patchwork of stuff. Okay.
Oh, yeah. This, Mr. Stevens, I mean, these are all Okay, Your Honor, as to case 23 F 1460, the people are unable to proceed as to count one, would ask that counts 2, 3, and 4 be remanded to district court. And then, sorry. As to case number 23 F 1442, the people are unable to proceed as to count one and ask that count 2 be remanded to district court. And then the people are unable to proceed as to case 24 F 2 1557.
Okay. Okay, so let's start with in case the ending in 1557, people being unable to proceed. Counsel, you're moving to dismiss.
Yeah, Judge, we would be moving for dismissal.
People being unable to proceed in that case, this case is dismissed on defendant's motion without prejudice. That's fine.
Another dismissal without prejudice. Pattern emerging. The prosecution, for whatever reason, cannot proceed, but without prejudice leaves the door open. Legally, that preserves prosecutorial power. Strategically, it prevents permanent loss of the case. For defendants, that limbo is exhausting. Freedom, but not closure. How long should the state have to bring charges again? Should there be stricter timelines to prevent repeated uncertainty?
Then on the case ending in 1442, count 1 is dismissed. The defendant continues his not guilty plea as to count 2. I will set a pretrial in that matter to DV. April 21st, 2025, 10 a.m.
Yes.
10 a.m. before Judge Washington. And in that matter is bond would continue. And then in the case ending in 1460, count 1 is dismissed. And he'll continue his not guilty pleas as to counts 2, 3, and 4. Pretrial in that matter will be set for
21st at 10 a.m.
April 21st, 2025, 10 a.m. before Judge Washington.
Because if I could address that.
Of course you. Go ahead.
Yes. So given that there were several felonies that were dismissed, especially in regards to case number ending in 1442, Mr. Love now faces a 93-day misdemeanor. He has been incarcerated since, I believe, February 14th, Valentine's Day, which is very fitting considering his last name is Love. But he has been in custody now for about 40 days, 45 days now. So given that he's served about 45 days on a 93-day misdemeanor, we'd ask the court to consider a personal bond. And I'd ask the court to consider a personal bond on the other case as well. He is 31 years old. Should he be released, he would be residing in Milan, Michigan with his brother. His brother is present in the courtroom. His brother has been actually present at all of the last court hearings and is very supportive of him. He does have employment lined up at Best Games. He would be working full-time there as a manager. It's my understanding it was confirmed that job is still available for him. He has 2 children. He has a high school diploma. He's very much involved in nonprofit, working with churches and helping do advertisements for the churches. He also has a connection to potentially secure alternative employment at Milan Metals as well. So we would ask the court to consider personal bonds on these matters. And we'd suggest any risk to the public or life could be accomplished via a tether.
Respond to the people.
No, I'll leave it in the discretion. The court would ask for the tether.
And you do understand, sir, that there is a no contact with Ms. Nobles.
Yes, Your Honor.
All right. Set his bond in each of these cases, $5,000 personal recognizance bond. Will also indicate that the defendant is to be placed on a GPS tether location tracking.
This is a major bond ruling. Personal recognizance means no upfront cash, but GPS tether means strict monitoring. That's freedom with surveillance. The defense argued employment, family support, time already served. Judge Simpson balanced that against public safety and alleged victims. The no contact condition reinforces seriousness. Violating that could land him back in custody immediately. Bond decisions are some of the most consequential rulings before trial. They affect employment, family stability, and case strategy. Do you believe GPS tether strikes the right balance between public safety and presumption of innocence? Or is it too invasive before conviction?
Thank you very much, Judge.
All right, thank you.
What we just witnessed was a full morning of courtroom reality. Waived examinations, dismissals, pleas, bond negotiations, amended charges, and through it all, Judge Simpson maintained procedural clarity and control. Each defendant faced a different crossroads. Some accepted plea deals to reduce exposure. Some benefited from prosecutorial inability to proceed. Others walked out monitored by GPS. The legal system isn't always explosive. Sometimes it's strategic chess. Quiet decisions with massive implications. Here's the professional takeaway. Preliminary waivers accelerate cases. Plea negotiations reduce sentencing risk. No contest pleas shield against civil liability. Dismissals without prejudice preserve prosecutorial authority. Bond rulings balance freedom and public safety. And now it's your turn. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.